Hi, I'm Ron Palmer from Fixed Family Courts, and I'm here to give you a First Amendment truth bomb that you can use to keep your judge under control, basically. The Constitution applies to your judge, the Constitution limits your judge, and you have rights and your children have rights, and those rights have to be respected even in a child custody suit between fit parents. And the most important rights you have, or the highest protected rights you have, are your First Amendment rights. And I'm going to give you a series of 9 different truth bombs that will help you put in front of your judge the requirement that your judge has to do more than just express his personal viewpoint about what is best for your child. Your judge actually has to pass First Amendment scrutiny before he can violate your rights. But you need to know what these rights are, and you need to understand how they apply, and here they are in simple terms. Right? Your relationship with your child is the source of constitutional protections for your parental rights. Let's say that again. It is not the marriage between you and the child's other parent that provides the source of your parental rights. If you are a natural parent, the child is biologically yours, then you have parental rights based on the association you establish with your child. A lot of people don't understand this. They're still stuck in this 19th century viewpoint that your parental rights are somehow dependent on your marriage to the child's other parent, and if that marriage goes away, your parental rights go away. And the judges and the family law courts and the family law codes in every state in this country are based on these outdated 19th century beliefs that have been invalidated by the Supreme Court, and yet they continue in family law. And the way to stop them is to assert your rights strongly and powerfully and force these courts to justify what they are doing. Your rights are not rights based on marriage. Your rights are individual rights. Your child's rights to you are individual rights, not rights related to a nuclear family or some fantasy idea of the perfect family. They're individual. One parent, one child, that's a protected association by the Constitution. And that association is protected as both an intimate and an expressive association by the First Amendment. Now, many attorneys will try to argue with you that your intimate association rights are only protected by the 14th Amendment and not by the First Amendment. They'll say that intimacy is protected under the definition of what is a liberty interest under the 14th Amendment, not under the First Amendment speech protections. They are totally wrong. They argued this with me years ago, and I dug and dug and dug until I proved that they were wrong. And the Supreme Court of the United States says they are wrong. All right? Now, the test to this is very simple. Anytime an attorney throws this at you or a state court judge throws this at you, you simply ask them, Your Honor, how is it possible to have an intimate association without expressing that intimacy to the other partner and that partner receiving that expression of intimacy? Without that, there's no intimate association. And therefore, an intimate association, while still a unique type of association, is undeniably an expressive association. They cannot be separated. Now, there are expressive associations that are not intimate, such as you're belonging to a political party, for instance. This is an expressive association of all the members of the party, but all the members of that party are not intimate with one another. They're not close. They don't share private aspects of their lives with one another, which are the hallmarks of an intimate association. Right? So always, always, always keep that in mind. Your intimate and expressive association with your child is an individual right that you and your child both have. It is protected as an individual right. It is protected as a First Amendment right. And you, as a fit natural parent, have every right to establish this association and maintain it. Now, your minor child cannot protect their rights on their own. They cannot express their rights on their own. But you, as their fit parent, have every right to say, my child is going to have an association with me, and because I am a fit parent that has a constitutionally protected right to make this choice, my child and I share a First Amendment protected intimate and expressive association. The Supreme Court has expressed this idea almost exactly like this, right? And let's talk about what they said. The Supreme Court said, we have emphasized that the First Amendment protects family relationships. Now, that's about as simple as it gets. Now, they said a whole lot of other things in this sentence, but the pieces of this sentence that matter, that absolutely hold true, is that we have emphasized that the First Amendment protects family relationships. Words of the Supreme Court, not my words. So your state court judge and the opposing attorney can argue all they want, but they're not arguing with me. They're not arguing with you. They're arguing with the United States Supreme Court. Good luck with that for them. Now, one of the things they'll throw at you is that the First Amendment says absolutely nothing about association. They're right. The word association is not in the First Amendment. So how is it a First Amendment protected right? It's what's called a penumbral right, or it's one of the rights that emanate from the First Amendment. And it's there and it's protected precisely because the First Amendment protects speech. But it doesn't protect speech in a vacuum. It doesn't protect your right to speak in an empty room. It protects your right to speak with other people, and it protects those other people's right to receive what you have to say. And that only happens if you can associate with those other people. And therefore, the right to association is undeniably essential and necessary to protect the right of speech. And so that's where the right of association comes from. That's why it's a First Amendment right. It's also protected by the 14th Amendment, and you'll see this quite a bit as a liberty interest, right? But that liberty interest, the definition of liberty in the 14th Amendment, incorporates the definitions of all the protected elements of the First Amendment. That's how the Supreme Court applies First Amendment protections to the states, by incorporating First Amendment definitions into the word liberty under the 14th Amendment. So even when the 14th Amendment protects your right of association against state action, it's protecting the definitions that are inherent in the First Amendment and those elements of individual liberty that the First Amendment protects. So in essence, when the court talks about 14th Amendment protections for association, it's not talking about a different kind of association or a different definition of association. It's talking about those associational definitions that are inherent in the First Amendment and the penumbral right of First Amendment speech and association. This is critical for you in a child custody case because you have the right to speak to your child, and as we'll see later, the right to educate your child, and your child has the right to receive that speech from you. From a purely intimate standpoint, a close family standpoint, you have the right to share intimacy with your child. Explain to your child that you love your child and that you care deeply about them and how they feel and what they believe and how they're getting along in life and all those things that matter to us from a concept of matters of conscience. Not matters that the state can interfere with, but private matters of personal choice and things like religion and your place in the world, your place in the universe. These are things that come from the heart, come from the most personal aspects of one's being, and they are protected as matters of conscience. And your intimate association with your child requires that expression, and it requires your child to be able to receive that. So when your custody court interferes with that, they are interfering with one of your most basic First Amendment rights and your child's most basic fundamental rights. And this is critical, because there are rules that come along with First Amendment violations. And those rules are very strong. There are a lot of them. They are well litigated. There are tons and tons of cases. The Supreme Court has said you have these rights. The Supreme Court has said children have these rights. Minor children have these rights. And they are protected against the government. They're not protected against parents telling the child what they can and can't say. But they are protected from the government telling your child what they can and can't say, or telling you what you can or can't say. So your state court judge cannot become a super parent and start dictating to you what you can and cannot say to your child. That is a clear violation of the First Amendment that will not survive any kind of challenge under a family code or the idea of a child's best interest. It's just absurd. And the courts would hold it so if they're proper courts applying First Amendment law. Right? So your rights to your child were inherently, when the Constitution was created, and even when the 14th Amendment was ratified, your rights to your child were a special type of property right. So when our founding fathers established the Constitution, and they thought about protecting parental rights, which surely they did, because several of them were parents. Thomas Jefferson was a single parent. His wife had died, and he spent many years abroad while his children, his daughters, were in the care of another family member. You think for a second Thomas Jefferson thought it was in the government's power to take his children away from him just because he was away as a diplomat in France? You're out of your mind. He did not. And he certainly thought the Constitution protected those rights under property law, because children are considered a certain type of property. And if you go back far enough in your state's codes and how they dealt with custody rights, you'll find that it was usually put into the state's property code. Now, we can no longer tolerate the idea of children as property, even if it was a special kind of non-chattel property. It's not like they were slaves, but they were treated as property in that the adult parent had pretty much total control over them, far more control than we have today. And rules of property were a good, clean way to deal with this, because they were clear rules, they were well understood, everybody understood them, and the courts knew how to deal with them and followed a strict set of rules. Now, the problem with that, of course, was that the property laws were applied unequally, right? And men owned all the property, women weren't allowed to own property, and that threw a big monkey wrench in all these things. And so in attempting to give women more authority over their children, they switched away from property rights, right? And ultimately where they got to, where the Supreme Court got to, is holding that when you come forward and create an association with your child and take over the responsibility of being a parent, you care for the child, you look out for their interests, that means the Constitution protects your rights. That's how your rights get protected by the Constitution. Now, with women, it's presumed this happens because they carry the child in their bodies for 9 months. They give birth to the child. They're there, obviously, when they give birth. And generally, people are witnessing all this. So the bond between mother and child is presumed because of this. Now, there are situations where this presumption would not hold. For instance, if the mother gave birth in isolation, nobody knew she was pregnant, which happens occasionally, and perhaps she abandoned the child immediately after she was raised, she might not have even known she was pregnant. That happens sometimes. Women don't even know they're pregnant and they have babies and they don't know what's going on. So these kind of situations, that presumption might not hold up, right? Especially if the mother abandons the baby and the baby's found, and then later the mother comes forward, then there's some things that the mother has to do to prove it. But other than those exceptional cases, mothers are usually presumed to be parents, the natural parent. Fathers, on the other hand, have to somehow assert their parental rights over their child. One of the ways this is done is if you're married to the mother, then the law generally presumes that you're the natural parent of the father. Your name goes on the birth certificate, and it's all presumed. And it's presumed you're the biological father. If this is not the case, there are ways to challenge all that. That's not what this is about. But the point is, because so many fathers deal with this, is that the moment you come forward and take care of your child and build that parent-child association, your rights receive constitutional protection under the First Amendment. This includes taking care of the mother while she's pregnant, right? Being there when the child's born, not necessarily in the room, but being there and caring for them, bringing them home, and doing all the things the new father would do with the child. Certainly feeding the child, caring for the child, all those things. If you do that, the Constitution protects your rights, and it protects them because of that association. That is the source, the First Amendment. So, in the early days, for all of our recorded history, before the early 1970s, the rights of parents didn't come from the First Amendment or the association. The law held that the rights of parents came from the marital relationship between the child's parents. If they were married to each other, then they were the parents because of that marriage. If they weren't married to each other, then the father had no rights to the child, and the child had no rights to the father. these fathers weren't even required to pay child support in a lot of places like Texas. There's a Supreme Court case about this in Texas where they changed that ultimately after the 1970s. But the law was that parents of these illegitimate or bastard children were not required to even care for their children. Now, most of the time the mother had rights to the child, but that's not an absolute. A lot of times the local governments took over rights of the child, so even the mother didn't have natural rights to the child if she had a child out of wedlock. A lot of times they would take the child and give them to another couple, those kind of things. Put them in homes for children. But all kind of things went on under what are called the bastardy codes. And then in the early 1970s, a series of cases came to the Supreme Court on different subjects, all related to the legitimacy of children. And the courts ultimately said that the law cannot punish a child for the sins of the parents. So if the parents do something that the government does not like, it is cruel and unjust to punish the child for what the parents did. And this is the law. And in all of those cases, there are about 7 or 8, 9 of them, the courts held very clearly that the rights are individual rights, not dependent on marriage, not dependent on a nuclear family. Individual. One parent, one child creates a family unit that is protected by the Constitution. Now, this transformed the landscape everywhere in law, where rights between parents and children mattered. Inheritance law was a big one, and several of these cases were about inheritance. And but the one place it didn't catch on was in family law between fit parents. So if you look at every family code in the state, or at least every one we've evaluated, and we've evaluated quite a few of them, every single one of these cases, or these family codes, is based on the outdated, discredited, overturned 19th century beliefs that your rights as a parent depend on your marriage to the child's other parent. And this is evidence in the statements that you will see in the family codes. One of them, for instance, in Texas, the judge is allowed to grant these natural parents' rights, parental rights, after they divorce. Well, that begs the question, how can you grant a right to someone who already has that right as a natural right that's protected by the Constitution? So what this is telling you is these family codes are presuming that the rights disappear simply because you got divorced. And so that says they are following the old 19th century bastardy codes that tied the rights of parents and children to the marriage. Those are unconstitutional. There's no way around that. The famous case that said that fathers had to care for their illegitimate children and child support was a Texas case, right, that went to the United States Supreme Court. The United States Supreme Court said, knock it off, Texas. If the child's entitled to care, then if a legitimate child's entitled to care, then an illegitimate child is entitled to care. It's that simple. There's no way around it because the rights are individual. So this is important to know. If you know and you realize that everything these family codes are doing and everything these child custody judges are doing has no foundation. It's based on 19th century beliefs that are discredited, overturned, unconstitutional. Everything they're doing is wrong, and they know it. Right? They only get away with it because you let them get away with it. And as long as you continue to let them get away with it, they will continue to do what they've always done. And what we're suggesting is that you use your First Amendment rights to put a stop to this. And you let them know that you know your rights are individual and they cannot be taken away from you simply because you either did not marry or because you divorced the child's other parents. Because when they do, what that is punishing you and punishing the child for rights, for your exercising a constitutionally protected right of choice regarding marriage. Your right to get married is a constitutionally protected choice. Your right to not get married is a constitutionally protected choice. And your right to dissolve the marital association is a constitutionally protected choice, as association rights protected by the First Amendment. Your right to associate also includes your right not to associate, either by never associating or by terminating an association. And your state can't punish you for that, and they certainly can't punish your child for that. Yet that's what they're doing. Right? So knowing that your rights are individual and protected by the First Amendment is vital. So this knowledge of individual, First Amendment protected parental rights changes this game completely. One of the things you'll realize after you realize the individual nature of the rights and the First Amendment protected nature of the rights is that your ex is really not the enemy. It feels like your ex is the enemy, and you've got a lot of emotion tied to the ex, and the ex is certainly trying to take your rights away from you. But the ex has no state power. They have no government power. They can try to take your rights away from you, but on their own, they cannot accomplish this. They have to reach out and exercise government power to take these rights away from you. And the individual that does that is your child custody judge. And your child custody judge is violating the Constitution every single day of his or her life, and they know it. At least the intelligent ones know it. And it's your job to put them on the spot and let them know that you know it too, and you're not going to tolerate it. Right? Now, there's a lot involved in that, and we help you with every stage of that. But this is the core part of it. Knowing that the real enemy in these cases, child custody suit, is not your ex, it's the judge. And the sooner you realize that, the sooner things will turn around in your case. If you're going and begging your enemy to give you something they don't want to give you, they may laugh in your face, or they may act like they're going to give it to you and torture you with the hope that they're going to give it to you. In the end, they're going to do whatever the heck they want, because they have the absolute power to do that, unless you know how to stop them. And the power that stops them is the First Amendment. So take this truth bomb, put it before your judge. Take the other 8 truth bombs, put them before your judge. Get the sample motions we provide. Get the education and knowledge we provide on our membership site, so that you know how to put this before the judge in a way that they cannot deny and that they cannot fight. Or you just go along with the system, beg the judge, and you get what you get. Whatever, it's just your kids, right? Your choice. You fight the corrupt system, knowing why the system's corrupt and how it's corrupt. Or you go along with the system and hope for the best. That's the only 2 choices you've got. Right? We like fighters. We're fighters. We fought and won. And we're here to help other fighters fight and win for their children. So good luck, and I'll see you at the next Truth Bomb.